All rise. Judge Vanderbeek Court is now in session. Judge, this is case number JVB 1034, Thornton case.
Thank you.
You're welcome.
You all may be seated.
Ladies and gentlemen, this case is about to take a complicated turn. On one side, we have a father seeking financial support, and on the other, a mother who is nowhere to be found, leaving their troubled teenager stuck in the middle of this legal mess. Mr. Thorne has stepped into the courtroom hoping for a fair outcome, but the big question remains, does he truly have a strong case, or is he about to face an impossible legal challenge? Let's break it all down.
Mr. Thornton,
Yes, ma'am.
you're back. How are you doing?
Oh, not as well as I'd like to.
Okay, all right. You brought this case before the court. What's going on?
Well, Your Honor, there's been some significant changes in my situation. And as you can see, Ms. Hernandez is not here today. And I have custody of the boy, and I have been, making our arrangement payments to her.
Okay.
But since the boy has come to stay with me, he's gotten himself into a lot of trouble.
Okay. What kind of trouble?
Okay, let's stop right here for a second. From the very start, it's clear that Mr. Thorne isn't feeling too optimistic, and honestly, who could blame him? He's been raising his son on his own, juggling both legal and medical bills that are piling up fast. But here's the twist. During mediation, he actually agreed to receive no child support. Now, the law follows strict rules, and unless Mr. Thorne can prove that something major in his situation has changed, his case isn't looking too strong. What do you think? Should a parent still have to provide financial support even if they've moved away? Share your thoughts in the comments.
He's been burglarizing some residents, and he was in an accident due to a police chase.
This is AJ, right?
Yes.
Okay.
And Ms. Hernandez refuses to acknowledge her responsibility to help me in covering some of these costs. I mean, the medical costs are quite extreme. My insurance is refusing to pay because it was a criminal act. In fact, they're probably going to drop me.
Okay.
And
if I remember correctly, you guys agreed to no child support during mediation.
yes, ma'am, we did.
Okay. And since that time, nothing has really changed with the living arrangement. AJ still lives with you,
Yes, ma'am.
and you still have not been paying child support. You've been making the back child support payments.
Yes, ma'am.
Okay. Other than AJ getting in trouble, what else has happened? Like, what has changed?
Well, she has moved out of state, quit her job, so her insurance no longer covers him.
Okay.
In that aspect. And the court costs, fines, and due to that accident, there was a lot of damage in which he's liable for, or I am, and it's almost impossible.
Okay.
For me to,
But AJ was double insured by both of you, right?
yes.
Okay. Here's the issue. In order to modify any type of child support situation, whether you receive child support or you don't receive child support.
Whoa, hold up. Did you catch that? This isn't just about unpaid child support anymore. We're looking at a serious criminal situation. AJ has gotten himself into real trouble, and now his dad is left picking up the pieces and the bills. To make matters worse, insurance companies don't cover criminal acts, so Mr. Thorne isn't just drowning in debt. There's a real chance his insurance could cancel on him completely. What would you do if you were in his shoes? Would you let AJ deal with the consequences on his own? Or would you keep fighting to get some help?
There has to be what's called a material and substantial change. That means that AJ's living arrangements would have had to have changed. Something about his educational expenses have changed. Something about mom's income would have had to have changed. But in you guys' case, you agreed in mediation to no child support. So to go from no child support to receiving child support, you would have to fall in one of those categories for a material and substantial change. And based on what you said, you really don't fall into one of those.
That's very disappointing. So she's just free of any obligation? I mean...
Well, I wouldn't say she's necessarily free, but remember, you all did come to an agreement in mediation to no child support. So in order to start receiving child support, you would have to show that something has changed. So let's say, for instance, at the time of mediation, AJ still resided with her. Now he lives with you, then we can entertain child support at that point. But nothing has really changed since you guys have gone to mediation. Therefore, you wouldn't be entitled to receive any child support, unfortunately.
I understand.
And this is where things really start going downhill. Mr. Thorne is hoping the court will give him some relief, but Texas law isn't giving him much to work with. From the court's perspective, nothing significant has changed, at least not enough to legally justify changing the child support agreement. Mediation agreements are binding, and unless Mr. Thorne can show clear proof of a major change in living conditions, income, or the child's needs, the judge can't do much. But honestly, shouldn't a parent still help out financially when their child is facing a serious crisis? Let us know what you think in the comments.
I mean, is there nothing I can do? Absolutely.
As far as I'm concerned, no, there's nothing you can do. Yeah.
All right. Thank you.
Okay,
Your
is
Honor.
there anything further?
No, ma'am. Not at this time.
Okay.
That's about it.
Okay, well, if there's nothing further, you're dismissed.
Thank you.
You're welcome.
Yikes. That's the harsh reality crashing down on Mr. Thorne. He was hoping for some financial help, but the law is pretty clear. An agreement is an agreement. Sure, the mom might still carry some moral responsibility, but legally, she doesn't have to pay a single dime. This is one of those situations where what feels fair and what the law says don't quite match up. What do you think? Should the law be more flexible in situations like this?
I just wanted to go over what you all witnessed in the Thornton case. Dad was appearing in court for the first time. He and mom settled at mediation for no child support. Well, now he wants mom to pay child support. Well, under Texas law, in order to modify child support, there has to be a material and substantial change. For example, there has to be a change in the child's mental needs, educational needs, a relocation of the parent, or an increase of income. None of those things took place in this particular case. Everything pretty much remained the same. Therefore, he was unable to get any child support from mom.
And that's a wrap. Case closed. Even with all the drama, the ruling didn't change. No major shift in circumstances means no child support. This is a hard lesson about legal agreements. Once you sign on that dotted line, getting a second chance isn't easy. But what do you think? Was justice really served here? Or did the system fail Mr. Thorne? Share your thoughts in the comments, hit that like button if this case opened your eyes, and subscribe for more shocking courtroom stories. See you in the next one.